I want to play out a reaction that we are getting from BJP MP Dr. Subramanian Swamy on the AIMPLB's decision to file for review.
AIMPLB, the Muslim Law Board, has come out and said that they will file a review petition in the Honorable Supreme Court with regards to the Ayodhya verdict. They say that we do not want the 5 acre of land. At the same time, they have said that there seems to be certain errors which we would be pointing out in the review petition.
Well, they haven't first of all, as far as 5 acres of land, they don't want it, no problem. It was a court offer. We didn't offer, none of the petitioners were asked about it. So they don't want it, no problem. In fact, in that case, we should ask the court to give it to the Shias, because it is originally Shia masjid, which the Sunnis have appropriated. And the Shias want to build it in Lucknow, no problem. You can find a place there in the suburbs of Lucknow, and they can build a Shia masjid. But as far as review is concerned, it is not a normal appeal like High Court to Supreme Court. There is no higher court than Supreme Court. Supreme Court can review its own orders. If you point out a major legal flaw or a blatant violation of facts. Now, I don't know what facts these people are talking about, but let me tell you, 1994, the Faruqi versus the Union of India judgment. It was a constitutional bench judgment, a formal constitutional bench judgment. Although it was this present one also of Ram Mandir is a 5 judgment, but it's not a constitutional bench. Faruqi was a constitutional bench and went to the constitutional issues. Here they didn't go into any constitutional issues. They went into the rights of individuals. Now, in that Faruqi judgment, it is stated that a masjid can be broken and shifted because there is nothing essential about prayer in a masjid except unless you show what it is. Makkah you can show, Medina you can show, and the rock near the Al-Aqsa Mosque also you can show, because Muhammad went to heaven from there. So there is a religious sanctification. But otherwise, all masjids all over the world, in Muslim world, is treated as a place for reading namaz. And namaz can be read anywhere, in the drawing room, in the aeroplane, in the road. So what error has been committed? And as far as whether the temple was demolished or not, yes, the ASI can be interpreted. I'm not sure it's correct interpretation, but it can be interpreted that they said we have no evidence that it was demolished. But that there was a temple they have established. And all that Narasimha Rao said as an assurance on behalf of the government to the Supreme Court in 1994 was that if there is a pre-existing temple, and there was a pre-existing temple. Babri Masjid, in fact, was built with the temple pillars and so on and so forth. You could see it. So I think when they say we are errors of what? Errors of law, then there is a serious review petition. But errors of fact, I mean, that is easy to make public. Let them make it public and tell us. But there is no errors of law at all. And as far as masjid is concerned, we never say, it has never been argued that it was there and it was demolished. Yes, Nirmohi Akhada said it, but Nirmohi Akhada's petition was dismissed. Only Ramlala's and the Ram Janmabhoomi Nyaya Samiti's petition was upheld. And of course, my point about faith, that was upheld. So I would say that this is a waste of time, but I think the hardliners are putting pressure. And in order to not have an allegation that they took money and became quiet, and they are doing this drama, it's a waste of time, it means nothing.